You have been a judge of the High Court for 6 years now.
Going on 6 years, yes.
Yes. And you were here previously for a vacancy at the Constitutional Court.
9th of July last year.
Yes. Just give us such information as you believe would be of assistance, just a few highlights that you believe would be of assistance in relation to this application.
Thank you, Chief Justice. I've been in practice 37 years and 2 days, to be precise. 16 years on the bench, and before that, 8 years as an attorney doing mainly arbitration and mediation. And so in total, I have some 24 years of my 37 years of practice serving as an independent and impartial intervener in disputes. Academically, I have used the 3 sabbaticals that I've had as a judge to advance my academic prowess. Firstly, I was at Seattle University teaching a course in international labor law. Then I went to Open University where I prepared course material. And then lastly, I was at Oxford University where I joined the group headed by discrimination and equality expert Sandra Fredman. And that inspired me to, well, publish an article, but also to pursue a course towards a doctorate with the University of Pretoria. That, I think, brings everybody up to speed as far as the essentials, I think.
Thank you. President Patti?
Thank you, Chief Justice. Good evening.
Good
Judge
evening,
Pillay.
President.
I know that you haven't acted in the SCA and that when you were interviewed for the Constitutional Court, I think somebody asked you whether you have acted, and I can't remember whether that commissioner asked you why you have not acted in the SCA, and you said, ask those 2 people in front, which was a reference.
Not exactly those words, but yes.
Something to that effect.
Yes.
And you were referring to me and the Chief Justice.
Yes.
Yes. But some time ago, you'll recall that I called you and talked to you about a chance to act in the SCA.
Retired Justice K.K. Mtiani called me when he was acting, and I think it was with your knowledge that he did call me. And it was just before I went on my sabbatical to Oxford, and he said when I come back, he would rearrange it, and that was in 2013 for my sabbatical in 2014. When I came back, I did drop you an email to say, I'm back in the saddle, to use my words, and you noted it, and that was that.
Well, when you said that, ask the 2 people in front there, I got the impression that you believed that you are entitled to act. Is that perception, if it's one, correct?
I don't have any sense of entitlement, Chief Justice. And that is why I'm pursuing a degree towards a doctorate, because I do need another challenge, and I'm quite happy if I don't get it from either of the appellate courts. I will get it through my academic pursuits. So I don't feel entitled to anything. If I'm suitable and you consider me appropriate, I'll be happy to act and to serve in that capacity.
Most of your experience is in the labor court, am I correct?
Well, 10 years of my experience there, yes, but as practicing as an attorney in human rights work was quite an unusual experience for most lawyers today, because it's a kind of work that few were privileged to experience. So my experience as an adjudicator, yes, 10 years in the labor court, and I suppose much of those 8 years was also labor related. But I think with a sound theoretical backing from my academic exposure, I should be able to deal with most situations.
Oh, okay. I'm looking at your questionnaire and note that in respect of your matters that went on appeal, 9 of them were unsuccessful appeals. Am I correct?
The ones that I listed?
Yes.
Yes, probably, you're right.
Well, were there more than those that you had listed?
Well, I think we're required to list about 10,
Ah,
and
yes.
that's what I did. And
Yes, no.
as I already had a pre-prepared application, I simply tweaked that for this process.
Yes, that I accept that the questionnaire requires 9 or 10.
Mm-hmm.
But
Yes.
are there more than that? Are there more appeals that were unsuccessful than the 9 that you have listed?
Well, more recently, the more recent ones that I haven't listed, and which one of which is the bar mentions, the Johannesburg bar mentions, and that is the Rossiter judgment, I think. And there's another one that I've been overturned. It's a full bench decision in a rape appeal that I'm aware of. So those are the late 2015, early 2016 judgments that I'm aware of.
And in those judgments, that rather appeals that were not unsuccessful, 2 had gone to the Supreme Court of Appeal, the ones that you have listed. It's the Edcon Consolidated
Oh, yes.
and Fenter versus Avonmore Supermarket.
Oh, yes. That was a successful judgment.
Yours was
I
a
succeeded,
successful judgment.
Yeah.
So the appeals against those judgments failed.
Yes.
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 And in respect of appeals that were successful, that is, your decisions having been successfully appealed, number 10 here in the questionnaire, whether more than 10 or is it only 10?
No, I'm sure there's more because I've said there that I've had a number of judgments. I tried to keep a record. Sorry, Chief Justice, which page am I?
Starts at page 15 of your questionnaire.
Okay. Yes, I did mention that there were there were more judgments that went on appeal, and I tried to keep track of what was overturned and what was upheld, to the extent that one can do that. But the ones that I had in my application, which I retained mostly, are the ones that I've listed here. And you asked for the application required 10, and I put in 10.
And in respect of the successful appeals against your judgments, what was your attitude there? Did you agree that you were correctly overturned?
In some of them, yes, so take, for instance, the most recent one that the bar raises, and that is that the Rossiter judgment with Nedbank. The Supreme Court of Appeal quite correctly pointed out that there was a procedural issue to be determined first, and it noted in that my judgment dealt with the matter substantively. And the bar doesn't record that. So the dispute about whether a matter should be dealt with substantively or procedurally is not an easy one. And in fact, it has surfaced in the Constitutional Court in the matter of MEC for Education and the Joint Liaison Committee, where the majority took the view that the issue should be decided in, as if the cause of action arose in terms of public law. The minority said that the senior counsel appearing had expressly disavowed public law, and they describe, the commentator, Cora Hoekster, analyzing this judgment, points out the tension between resolving disputes substantively and resolving them procedurally. But coming back to my judgment, in my case, in the case that I had to deal with, this was not a loan from Nedbank to poor individuals for a bond on their houses. It was a loan of about 11 million rand to a trust, and they hadn't paid that back. And they raised what in the profession we call a shotgun defense. In other words, they struck at many points without, and the hope that one would hit home. And I felt that prolonging the agony and the non-payment of this debt, considering also that there had been attachments which hadn't been released, and the Supreme Court of Appeal's judgment observes that. So, to cut a long story short, there are different approaches to any set of facts. And sometimes you can say that there's a right and a wrong decision, but sometimes you must say that there are different approaches. And in that case, there was a different approach. I think the one thing you can say about all my judgments that went on appeal, whether they've been upheld or overturned, is that none of them is there any observation from the Supreme Court of Appeal or even the Constitutional Court that I was irrational or that I didn't apply my mind to anything? So I have applied my mind to everything that needed to be applied. I might have come to a different conclusion, but we will see. And you will see in the article that Cora Hoekster has written in the latest South African Law Journal of how this plays out, even in the Constitutional Court.
No, I asked that question because usually one learns from the higher court's decision. If they overturn you, you look at it and you say, yes, that's where I went wrong. That's why I'm asking you whether you were happy with, when you read those judgments that overturned you, that you were correctly overturned.
Yes, and some of them I am educated about a different way of thinking. But let me draw your attention to another phenomenon that happens. I've been criticized in the MEC for Education matter by the Labour Appeal Court, apparently, and that matter went to the Constitutional Court. Incidentally, the Supreme Court of Appeal in that matter refused the petition for leave to appeal. But the issue on which the Constitutional Court decided the matter was not an issue that was argued before me. The Constitutional Court decided the matter on the argument it heard there, and that was Section 237. Section 237 of the Constitution wasn't raised before me. So, yes, I do understand, and I don't have any problems that it was decided on a different point. I am satisfied that my judgment was rational. I would like to point out also that the judgment of the Labour Appeal Court stridently criticized me towards the end of their judgment in the language that I've used, and the bar suggests that I have an intemperate indignation about some of these issues, constitutional issues. I had a careful look at that judgment since my last sitting here, and I noticed that the Labour Appeal Court did not look at Section 195 of the Constitution, did not look at Njongi, which is a Constitutional Court decision, or the PEP Court decision from the Supreme Court of Appeal, all of which deal with public accountability. And that explains the intensity with which that criticism is leveled at me. The Constitutional Court based its judgment on some of those decisions and extensively quoted Section 195. Sorry, can I have a glass here, a clean glass, please?
I'm sorry about that. It's what you responded earlier when I asked you about acting in the SCA or Constitutional Court was correct, that Deputy President then, Mtiane,
Yes.
called you on my suggestion. But you weren't invited to act in the SCA in the end
Yes.
because and I'd like you to comment on that, the view of colleagues in the SCA was that you are mainly comfortable in labor law and little experience in the other branches of the law. What's your comment to that?
I think my judgments speak for themselves. I try to write up everything that comes before me in a way that is that makes a contribution. And I noticed that one of the bar reports say that I don't have enough commercial experience. If I don't get a commercial case, I can't decide it. I decided, and you can see from my record of published judgments, I probably have one of the highest number of published judgments, 40 in the High Court. So I do the best I can, and if you don't give me the experience, I mean you in the plural, not you specifically, that's it.
You mean if you are not allocated
If I'm not allocated
give
cases,
you experience?
Yes, but I don't feel uncomfortable with acting in that position because my experience is not limited to labor law. My experience extends to human rights work. My experience extends to constitutional work. And as the bar report points out, I raise constitutional issues when even the practitioners don't. So I am completely tuned in to human rights, to the Bill of Rights, and to the Constitution. So as I've said in my previous interview, I've been thrown in the deep end before. I set up the Essential Services Committee with nothing to follow, and I served there for 5 years, and I've set up the jurisprudence for that. Pretty much worked myself out of a job there. But I'm not afraid of a new challenge, and as I said, I do want a new challenge, and if an appellate court won't give it to me, I will find it in my academic work.
Thank you, Chief Justice.
Thank you, President Patti. Commissioner Semenya.
Chief Justice, thank you. Judge, where does one draw the line? What type of areas require public office bearers to be sanctioned by their voters, and areas where the courts must speak?
The courts will speak only when they are asked to, and that means an application or an action is brought.
Perhaps if I may try to elucidate, are there issues which are purely political and others legal?
I think Judge Dennis Davis has written extensively on this topic, as have many other academics. Everything is political. The allocation of resources is political. So even when you're deciding a case legally, you've got to look at how the politics plays into it. I'm not talking about party politics. The politics of education, the politics of housing, health, all of that. The Constitution is political.
I noticed in one of the judgments of the Constitutional Court, they elected not to deal with a matter they thought requires the faith-based people to resolve than the courts. Would that approach be okay with you?
Well, I'm not familiar with which matter you're talking about, but it depends on the circumstances.
Let me help.
Yes,
It's a matter whose papers you must read to be able to understand it properly. That is what should have been done.
yes.
At a certain level, it wasn't done, and therefore it could not be resolved at the Constitutional Court level.
I can
The
understand.
De Lange matter.
Okay. Well, let me respond this way. I think because because adjudication is a form of participation, and if there's a kind of participation in that decision making that should have taken place at an earlier step, such as an interested group having an input in the decision, such as the faith-based people, as you mentioned, then the judgment of the court can be deferred until there has been better participation by the persons involved or interested in the outcome.
At arbitration level in this case.
There you go.
Thank you, Chief Justice.
Commissioners, may I excuse, or Commissioner Malema?
Thank you, Chief Justice. Let me understand you properly, Judge, about politics. You're saying when a judge makes a judgment, must take into consideration politics.
Yes.
Is that what you're saying?
The politics of the subject matter. So how, for instance, how the budget is allocated, how the political system works to, for instance. Yes.
So if a judge, a judgment, what is more important in this judgment? Is its political correctness or its legal correctness?
It's not necessarily mutually exclusive.
Can a decision be politically correct but legally wrong?
Well, it has to be legally correct.
Can a decision be politically correct and legally wrong?
It has to be legally correct. If the politics inform the legality, then the politics must be taken into account. If the politics is irrelevant, it doesn't inform the legality.
So what matters is the legality, not politics. Huh?
Well, I'm thinking.
Oh,
Well, I can't think of an example straight away, but perhaps in there is a matter, in fact, that came before the Constitutional Court. It's a delict. A person was injured a rugby player, I think, was injured on the soccer field, and there was a delay in his medical treatment. So the Constitutional Court awarded him damages. But even there, to some extent, possibly the politics of health and how the health system works might come into play. But this was purely delictual, and the court decided to award him damages.
will I be correct to say politics have got nothing to do with your job?
No, you won't be correct.
No, your job is to apply the law and not politics.
I don't think you understand, Mr. Malema, that what I mean by politics. I mean, for instance, the way the budget is allocated and distributed is political. It is a political process. I am not talking about party politics.
I've not gone to party politics.
Yep.
I don't want to go there because your CV speaks about where you come from. I don't want to go there. I'm sticking to what you said. And I'm saying the responsibility of a judge, especially a judge going to a superior court like the SCA, is to apply the law and have nothing to do with politics.
Well, that's your interpretation, Mr. Malema.
So you still
But-
insist that judges must apply politics?
No, you're not listening to me. What I'm saying, Chief Justice, is that even law is political. The fact that our political system sets up a judiciary, that's political. And the way the system, the judicial system works, that's political.
Thank you.
Thank you, Commissioner Malema. Commissioner Mudise.
Thank you, Chief Justice. Good evening, ma'am.
Good evening.
What are the obstacles, in your opinion, to justice in South Africa?
Access in all forms of that word. Resources, to start with, distance from points of delivery of access, of justice. Legal aid should be better funded. There are only a few NGOs who are taking up constitutional challenges, and they are dependent on public funding. So all of that, yes, and more, I'm sure.
Ma'am, you are also, would you agree that sometimes the courtroom is intimidating? And that could be seen as one of the obstacles
Well,
to people speaking freely and putting their cases clearly?
yes, I'm sure it must be intimidating to many lay people. But the courtroom has to be such that the judge or judges retain control of the environment, that there's respect for those who speak, that the acoustics, when they're bad, can be overcome without any noise disturbances. But also the atmosphere must be such that it induces the truth.
Would you also agree that when the presiding officer comes across as a little bit impatient, that can also be negative?
Sure, yes, it can be.
And would you also remember that, in fact, the Johannesburg Bar once complained about your seemingly not being very nicely entertaining to people who take a little bit of a roundabout to put their matters? Can be intimidating?
Well, I answered that in my previous sitting here, and I answered it this way, that we have 5 hours of court time and I must manage it. And if someone is not saying something relevant to the decision or to the court or to the case, then I must interrupt. But also, I am excruciatingly mindful that a judgment is a product of listening to the proof, the argument, and coming up with a reasoned judgment. If I don't get either the proof or the argument, I can't come up with a judgment. So I have to listen.
With respect, but perhaps I should leave it at that. What is your understanding of judicial independence?
Well, structurally, we're independent because we're appointed by the JSC. Institutionally, we operate under the OCJ. In terms of our, the performance of our duty, we owe an allegiance to the Constitution. And we take an oath of office to execute our duties faithfully to the Constitution without fear, favor, or prejudice. So all of those things go towards independence.
And about judicial accountability?
That we are accountable to the parties we serve, to the Constitution, to the parties, yes, as I said. Our judgments must reflect what is presented to us in some way, to the extent that we agree or disagree with what was presented to us in the way of proof and argument. So that's the first level of accountability. We're accountable to the parties in terms of delivering a judgment expeditiously and one that they understand. We're accountable to the development of jurisprudence in a consistent and coherent way. Those are some of the ways in which we are accountable.
CJ, thank you.
Thank you, Commissioner. Commissioner Singh?
Thank you, CJ. Good evening, Judge Pillay. Good evening. I'm just trying to understand, and you can correct me if I'm wrong, is in your stint as a labor court judge and a high court judge, you sat alone and it was your judgment on a matter? Or were there cases where you sat with other judges?
Well, in the appeal court, we do sit with other judges. A full court, we sit with 2 other judges, and a full bench, I sit with 1 other judge.
Yeah, the reason I asked that question, because, you know, my understanding of the SCA is that 5 judges sit there.
Yes.
And I just want to try and get your sense of being a team player. If you can just tell us about, you know, being a team player when more than 1 judge has to sit and adjudicate on a matter.
My colleagues will vouch for me, and some of them will be appearing before you can get corroboration from them. But I offer to write the judgments, mostly, if we're sitting in full court appeals, and I've done some of them which have been reported. I enjoy writing, and I try to write persuasively so that I get concurrence from the other judges. So I haven't had a problem. And of course, there's one matter in which we disagreed, but we agreed to disagree, and that's a Mabaso matter which you have before you.
So in most cases, just to follow up, in most cases you've had concurrence. You try and get concurrence, you
Yes,
say.
and the important ones, yes. Well, all of them are important, but the 2 significant ones that were groundbreaking in some senses was the Shaw judgment, which dealt with circumstantial evidence, and there was I found authority in the Dango dog case in Australia to support my view, and the JP at the time, Patel, and another colleague, Lopes, joined me in that judgment. And more recently, in the Nandlal and private prosecution case, which you also have with you, my colleagues who were both senior to me joined in that judgment.
Thank you, CJ. Thank you.
Thank you, Commissioner. Just to round up and following up on that accountability issue that was raised, purely on the assumption that every human being is capable of making mistakes, and serious mistakes for that matter. And therefore, just because you are a judge doesn't immunize you against making errors which could have been obviated or corrected through an accountability, a system of accountability. I ask the following. Sometimes you hear rumors that some judicial officers, whether they are magistrates or judges, on Wednesdays, no sitting, golf. True or false? Sometimes you hear that there are unnecessary delays in the finalizations of matters. Somebody goes on circuit or periodical court. You arrive there unexpectedly as a head of court. You find the person asleep because you got some tip off that there hasn't been any sitting. Person is opening a mouth on a chair, is fast asleep. And sometimes you learn for the first time from the media that there is a judgment that has been pending for a long time, 2 years or so. And you have never been told as an interested party in the running of these sort of things. What is it? And I ask the question because we don't pay ourselves. The taxpayer pays us. We are there to be independent, but also to be accountable. We don't pay ourselves. What is it that could be done to preserve, among other things, the integrity, the image of the institution, but also to hold even judicial officers accountable?
Chief Justice, I think you've started sorry.
Yes, no, carry on, carry on.
You've started some process of getting that accountability in terms of having daily, if not weekly, reports of what judges do and how much time they spend in court. I know my registrar is often filling in some forms that she sends to you about me, and other registrars do the same.
Well, just to interrupt, some believe that it's policing judges and interfering unduly with their independence.
Well, that's one way of doing it, but there's another way of doing it is to keep an eye on the number of judgments that are generated, how many are reserved and not delivered, and how many go on appeal and are overturned to assess the competence of judges. But going back to the first part of your preamble to the question, and that is about the fallibility of judges. Of course, we're all fallible, and hence we have 11 judges sitting in the highest court and a large number in the appellate court. And we know that sitting as a puisne judge, there's somebody looking over our shoulder. So that's good, but we're also human, and when we're incensed, as we sometimes criticize for being incensed, and I'm not the only judge who gets indignant about violations of the Constitution. Cora Hoekstra has made that observation of the minority scribe in the judgment that I referred to, where you sided with the minority as well, as she said that he was infuriated and that he was outraged by the acceptance by the majority of the public law line of argument. So it's comforting to know that somebody looks over our shoulder, and we have to do the best we can. Chief Justice, may I just take the opportunity to clear up any misconception that might have arisen from the last comment that Mr. Malema made?
No, you'll do that. I'm still on accountability.
Okay.
You see, the 11 judges at the Constitutional Court will never be able to pick up the golf match issue. They can only deal with judgments. So what system must be in place to ensure that we all do what we are employed to do? Not because we are being policed, but because every human being, no matter your profession, is capable of making serious mistakes to the prejudice of others. So the golf course issue, the sleeping, somebody assumes that you are working for the whole week until there is a tip-off, and indeed they get there, there's never been any sitting, you are just sleeping in your office. Just as an awkward example. So what is it then that could be done? You don't want to interfere with independence, but you also know that the taxpayer is footing the bill for a reason.
Sure. Sorry, I didn't realize I didn't answer that part of your question. To the extent that I'm able to, I think there's two angles to this. And one is that when candidates apply for appointment to the bench, I think one needs to check whether they are applying so that they can secure a pension, or whether they're applying because they have a commitment to public service. And I think the grueling that one gets in this forum can go some way to to assessing that, but I think the profession needs to be far more involved in reporting on candidates. Not just the profession, but I think the public. We don't have enough participation. And if you look at the contributions that we've had to this round of interviews, it's a serious process, and we've only had a repeat of the last report that from the General Council of the Bar, Johannesburg, and we've had a report from the province. It's not enough, and civil society needs to be more engaged in that process. The second thing, I think, is perhaps a system of nudging people and encouraging people and giving them the tools to overcome phobias and reluctance to write. And I think the longer you leave a judgment, the harder it is to write it. So from my own experience, I write almost immediately after a hearing, at least my formative thoughts. So when I come back to it, I know I have an first impression, and it's easier to get back into it. Many people find it formidable and don't get into it until it gets worse and worse. So I think if we, in the SARJ processes and every other forum that we can, encourage that, in fact, what I'm saying is put up some carrots rather than hitting with a stick to encourage. Well, the stick might be necessary, and your committee, and you have a tribunal to sort that out. But the one thing I can say, though, Chief Justice, is that to the best of my knowledge, the colleagues in my division, even those who play golf, don't have a pile of reserve judgments, and they are attentive to their responsibilities.
No, I'm not accusing anybody
No,
of
no, I
anything.
know you're not.
I'm just looking into accountability from another perspective. But you wanted to deal with Commissioner Malema's issue.
Yes, he made a remark in passing which I didn't get to respond to, and that was, we know where you come from, and in relation to my politics. My politics, for the record, is that as a child, my parents were members of the Unity Movement. When I went to university, I was influenced by the Black consciousness. In the 1979, when I started practice, other organizations came into my life, the Release Mandela Campaign, the UDF, the Mass Democratic Movement, the Italian Congress, and so on. And when I joined the bench, I have not belonged to any political organization, and my independence is unquestioned by the bar, and I have no qualms about my history. It has taught me how difficult it is to play in that political terrain, and how privileged I am to serve in an independent capacity. Thank you, Chief Justice.
Thank you very much, Judge Pillay. You are excused.
Thank you.
Oh no, there's a commissioner who has raised there. Commissioner Ntama?
Thank you, Chief Justice. Good evening, Judge Pillay.
Good evening.
It's just one question. Just on the transformation of your division, particularly the jurisprudence that emanates from your division, or maybe you share it amongst the colleagues. There is a judgment that is worrying me, that was delivered last year, November, by Judge Orsalin in Williams versus Minister of Police, where on the assessment of the evidence, Judge Orsalin made a distinction on his assessment of the evidence based on the articulation of English vis-a-vis the indigenous language. The issue was the brawl of a white policeman vis-a-vis the black man, wherein the judge gave credence to how well English was spoken by the white man, as opposed to the black man who was so embarrassed, who couldn't even look at the eyes. I'm not sure whether you are sharing that or you are aware of that judgment?
I'm not aware of Judge Olson's judgment that you're talking about, but what
Okay,
is your
sir.
question?
Okay, then we can leave it that.
Thank you.
My question was on the transformation of your division, particularly on the evolution of the jurisprudence relating to the advancement.
We do our best to encourage underrepresented categories, women and African members of the profession, to come act. It's not easy to get competent people who are going to deliver judgments quickly, who are not going to be afraid of civil work. So we do the best we can.
You are now excused,
Thank you.
Judge Pillay. Thank you.